Welcome to the Family Law Channel. The U.S. Supreme Court this week ruled that a Florida man's children conceived after his death through in vitro fertilization are not entitled to Social Security survivors' benefits. There are now more than 100 similar cases pending before the Social Security Administration. The ruling this week is unlikely to resolve, though, most of them. But the Supreme Court did rule unanimously. My guest is the host of the Family Law Channel here on the Legal Broadcast Network, retired Superior Court Judge Eugene Hyman in Santa Clara, California. Interesting case, Judge. Thanks for joining us.
Thank you.
This brings up a whole, array of possibilities here, but talk about what this ruling means, and in your mind, there is a way to circumvent this.
Right. As I understood the Supreme Court's decision, if the testator, that is the father who passed away prior to the children being born, had provided for them in his will, then they would have been covered as survivors for purposes of state law as well as Social Security. He didn't. He didn't address the matter. He didn't state in his will that he and his wife were trying to artificially conceive a child, and that this child might be conceived prior to his death or after his death, but either way, that it was his intent that this child inherit under his will. If he had done that, then it would appear, given the decision, that his children would have been eligible for survivor benefits under Social Security.
Mm-hmm. And the Social Security, I mean, in one sense, because they're having so many financial problems right now, their argument was we don't want to open up a Pandora's box of, you could extrapolate all kinds of things happening if the Supreme Court was to rule the other way. But seriously, the way with technology is developing in this area, the ability to not only create children in this manner, but also to diagnose disease way ahead of time. It seems like this isn't something that's going to go away.
Oh, no, absolutely not. But what will be interesting to see what Congress's response to this will be, if anything. Given a lot of the sentiments of those that are extremely religious, they might view this that if it's going to be done artificially, then they shouldn't be covered. The other thing that's interesting is that the court's interpretation of the Social Security laws are that the states decide the inheritance, which is traditionally a state's decision-making, but easily Congress could modify the Social Security rules and say that any child that is not in existence or at least conceived prior to a testator's death is not covered. I mean, Congress could certainly do that. If they wanted to. And I think maybe after this decision, since it's bringing this issue to the forefront, that's something that in fact might happen.
Mm-hmm. And you could also see, I guess my question here is that, so now the Social Security Administration pays benefits depending on what the rulings are in each individual state.
Correct.
And there could be a sweeping congressional ruling one way or the other where they said kids are kids, and if they're your kids, they deserve to get the benefits.
Right. I don't see it a situation where they would I could see a situation where Congress would say if the child is not conceived prior to death, then the child won't be covered. I don't think there would be a situation where Congress is going to say that if a child is conceived with either the egg or the sperm of a deceased, that person's going to be covered, because that just leaves open too much unknown with respect to the persons who have access and control of either the sperms or the eggs.
Now, in your mind, with relation to family law and creating families in this manner, is it a common practice? Do people see far enough ahead to include this type of stipulation in a trust or a will?
I have heard people in their wills saying what is to happen with their genetic reproductive material, whether it be eggs or sperms. And I have heard of cases where a person in a testamentary device, a will, said that upon my death I want my sperm or my eggs destroyed. they didn't want them used after their death. But also, or the other alternative is giving the power to the partner to use their sperm or their eggs as the partner deems fit. That's also been cases that I've heard of.
Mm-hmm. And what is interesting also here is how the woman in this particular case, Karen Capato, in her challenge in the denial of benefits, she contended that the Social Security Administration had misread the statute, and it does clearly say that the word child is clearly defined in the 1939 Social Security Act as the biological offspring of a married couple, yet the Supreme Court looked at that and decided to rule the other way.
Well, they said that one of the justices said that a marriage no longer exists after the death of one of the partners. So that was one interpretation that, yes, of a married couple. I mean, you get into all kinds of interesting things in terms of what if the people were gay but they were married, or gay or lesbian and they were married. There's all kinds of possibilities. But again, this is what the Supreme Court is talking about is strictly with respect to Social Security. It's going to be up to the laws of each state. I mean, even California, which presently does not recognize gay marriage, would have to recognize gay marriage that took place prior to the prohibition, and further, under full faith and credit, has to recognize gay marriages that are authorized by other states. So that doesn't take care of the problem unless the federal government or Congress would modify the Social Security statutes to say, hey, if the child is not in being at the time of the person's death, then they don't receive a benefit.
Well, one good thing we can be thankful for is that we have full access to great judicial minds like yourself on a daily basis. Judge Hyman, thanks for joining us today.
Thank you.
And this is the Family Law Channel, a proud affiliate of the Legal Broadcast Network.